Hello, everyone. In today's presentation, I'm analyzing the Priceline User Agreement, also known as the Terms and Conditions, specifically Part 1, Sections A through F. My goal is to evaluate whether it constitutes a value contract, whether visitors are bound to it, or the users can sue Priceline in the event of a dispute, and what changes I could recommend. First, is Priceline User Agreement a valid contract? Under traditional contract law, a valid contract requires offer, acceptance, consideration, and mutual assent. Priceline presents its terms and conditions as the governing rules for using its platform. It constitutes the offer. The consideration exists because Priceline provides access to travel booking services, and in exchange, users agree to abide by the stated rules. The critical issue becomes whether there is a meaningful acceptance and mutual assent. Modern online contracts typically fall into two categories: click wrap and browse wrap. Click wrap agreements require users to affirmatively click "I agree" before proceeding. Browse wrap agreements simply post the terms on the website, usually in a footer link, and assume assent by continued use. Courts generally favor click wrap agreements because they demonstrate clear assent. Browse wrap agreements are enforceable only when users had actual or constructive notice of the terms. Eric Goldman cautions against assuming that simply posting terms online automatically binds users. Courts increasingly analyze whether the reasonable user would understand they are entering into a contract. Therefore, the Priceline user agreement can be a valid contract, but its enforceability depends heavily on how assent is attained. Second, are visitors bound to terms, or should they have a click "I agree"? In my view, users should be required to click "I agree" before completing a booking or creating an account. If Priceline relies solely on passive notice, such as a footer hyperlink, it resembles browse wrap. Courts may refuse to enforce key provisions, especially in abbreviation clauses, if users were not clearly informed. The digital media law emphasizes that enforceability hinges on notice and manifestation of assent. Requiring affirmative click wrap consent would strengthen enforceability and reduce ambiguity. While some courts have upheld browse wrap agreements when notice is conspicuous, relying on an approach that creates unnecessary legal risk. Third, if you have a dispute with Priceline, you can sue them. Most large online platforms include mandatory abbreviation clauses and class action waivers in their terms. Abbreviation provides provisions require disputes to be resolved privately rather than in court. If Priceline terms contain such a clause and the user validly assented to it, then the user generally cannot sue in judicial court and must instead pursue arbitration. The Electronic Frontier Foundation has raised concerns about forced arbitration clauses in digital contracts, arguing that they can limit consumer remedies and reduce accountability. However, the Federal Arbitration Act courts frequently enforce arbitration clauses unless they are peculiarly or substantially unconscionable. Therefore, whether you sue Priceline depends on two factors. First, whether they are in arbitration clause, and second, whether the court finds you meaningfully agreed to it. If the assent is weak, for example, unclear browse wrap, the court might decline enforce the arbitration provision. Fourth, what changes would I recommend? I recommend several improvements to strengthen the enforceability and fairness. 1. Mandatory click wrap consent before completing a transaction. 2. Clear, bold disclosure arbitration clauses and class action waivers. 3. A plain language summary of key rights and limitations. 4. A limited opt-out period of arbitration allowing users to reject it with a specific time frame. These changes will not only reduce legal risks for Priceline, but also enhance transparency and trust. Courts increasingly scrutinize digital agreements for fairness and clarity, stronger disclosure practices, and demonstrate good faith and informed consent. In conclusion, Priceline user agreement likely qualifies as a contract and structure. However, enforceability depends on how assent is attained. Users can be required to click agree to assure clear acceptance. If a dispute arises, arbitration clauses may limit the ability to sue in court, but those clauses are enforceable only if valid assent exists. And ultimately, improving transparency and requiring affirmative consent will be better balanced